evil.
It was just a disgusting scene.
Those comments from Ohio's top cop and a sheriff have attorneys for members of the Ciders family fired up.
We saw down here today is pure evil. It was just a disgusting scene. That sound is from the very officials now legally barred from speaking. But listen closer. This is not just audio from a crime scene. It is a door being sealed shut, the lock clicking so fast you might miss it. Imagine a courthouse where the only sound is the scratch of a pen on a proposed order. Signed in a moment with no debate, no evidence, and no hearing. That signature didn't just gag a sheriff and an attorney general. It silenced an entire system of public accountability for what was found inside an Ohio house of horrors. Before we go deeper into what the documents actually show, make sure you're subscribed to Endless Cryme, because we don't just cover the story, we follow the evidence.
15 children were found in that house in Vinton County, Ohio, in conditions described as disgusting, deplorable. The sheriff said animals aren't even kept that way in Vinton County. The parents of those 16 children, Gary Ciders Jr. and Elizabeth Ciders, they're in jail. They're facing 16 counts of child endangering. Gary Jr.'s parents, Gary Sr. and Christina Lynn Ciders, they face the same charges. All have pleaded not guilty. Only Gary Sr. is out of jail receiving care for a serious medical condition that could have bankrupted the county. That's how small and poor Vinton County is. Caring for an inmate with a serious medical condition.
16 children discovered in Vinton County, Ohio, living in conditions the sheriff said animals aren't kept in. Feces, roaches, trash. The parents, Gary Ciders Jr. and Elizabeth Ciders, are in jail on 16 counts of child endangering. Gary Jr.'s parents, Gary Sr. and Christina Lynn Ciders, face the same charges. All have pleaded not guilty. Only Gary Sr. is out, receiving care for a medical condition so serious it could have bankrupted the smallest county in the state. That detail is not color commentary, it is the financial foundation of what happens next. When a county is that small and that poor, the machinery of justice moves at a different speed under a different kind of pressure. And pressure in a community of 13,000 people can crush the flow of information faster than any court order.
That need to be answered here. Were Gary Jr. and Elizabeth receiving state benefits like food stamps or financial assistance for themselves and their 16 children? If they were, was anyone checking in with them? We've told you that Children's Services in neighboring Gallia County had had some type of contact with the Ciders, and we showed you the truancy complaints filed against Elizabeth and Gary Jr. after the Gallia County School District said their 6 oldest children didn't attend school. The children were at risk for being labeled unruly, and the district said they were habitually truant. I'm looking into whether Elizabeth Ciders may have tried.
The question started immediately. Were the Ciders receiving state benefits like food stamps or financial assistance? If they were, was anyone checking in? We know neighboring Gallia County's Children's Services had contact with this family. Truancy complaints were filed after the 6 oldest children simply vanished from school rolls, and there are indications Elizabeth Ciders may have tried to get other government benefits, perhaps denied. It is inconceivable to most people how 16 children could be kept in a room off the radar, with no one seeming to know. That inconceivability became a legal problem for the defense.
Doesn't like it. The attorney for Gary Jr., R. Lee Roberts, filed a motion for a gag order this week. He doesn't want anyone associated with this case, or any public official at all, talking about it. Here are some of the comments that have upset Roberts.
Our livestock was kept in better conditions than the children. It was just a disgusting scene.
Some of these children could even speak. It looked like almost feral animals. It was terrible.
And I've been doing these types of cases for a long time. I spent a big portion of my career dedicated to prosecuting these types of cases. And I can tell you this is pure evil. What we saw down here today is pure evil.
The attorney for Gary Jr., Arlie Lee Roberts, filed a motion for a gag order this week. He doesn't want anyone associated with this case talking about it. The comments that upset him included the sheriff comparing the home to livestock conditions, the description of children unable to speak, looking like feral animals, and the attorney general calling it pure evil. Roberts argued that in a county this small, those words taint the jury pool beyond repair.
Wants everyone to stop talking. In his motion for a gag order, Roberts wrote, "These statements have resulted in a substantial probability that the defendant's right to a fair trial will be prejudiced by publicity, and a gag order can prevent further damaging statements. The case revolves around the state of the children at the time this case was filed. The descriptions of the children that have been issued by the public officials involved in this case seek to do nothing other than inflame the heart and passion of the potential jurors. These concerns are amplified by the nature of the small community in which the instant case occurs. There are no other reasonable alternatives available to adequately protect defendants' right to a fair trial. Unfortunately, a gag order is the only mechanism available to the court and defendant to preserve his...
In his motion, Roberts wrote, "These statements have resulted in a substantial probability that the defendant's right to a fair trial will be prejudiced by publicity. The descriptions of the children seek to do nothing other than inflame the heart and passion of potential jurors. These concerns are amplified by the nature of the small community. There are no other reasonable alternatives available to adequately protect the defendant's right to a fair trial." That language is standard. What happened next was not.
Spot, without hearing from the prosecution or holding a hearing. The order reads in part, "The court finds, given the publicity thus far, that any statements made to media by the Ohio Attorney General's Office, the Vinton County Prosecutor's Office, Vinton County Clerk of Courts, and the Vinton County Sheriff's Office, and any other party related to the investigation or prosecution of the alleged crimes, including defense counsel, would create a reasonable likelihood of prejudicial pre-trial publicity, which may impact the ability to impanel an impartial jury. The court finds the following least restrictive and reasonable constraints are necessary to avoid any potential prejudice, whether real or perceived, to protect the judicial process. Therefore, in the administration of justice and to protect the rights of the defendant from prejudice during this proceeding and interests of the state, the court hereby prohibits all parties to this action, any attorneys and respective staff connected with this case in any manner."
The motion included a proposed order. Judge Lena Feather Rogers signed it on the spot. No hearing. No response from the prosecution. No evidence presented. The order finds that any statements by the Ohio Attorney General's Office, the Vinton County Prosecutor, the Clerk of Courts, the Sheriff's Office, and any other party related to the investigation would create a reasonable likelihood of prejudicial pre-trial publicity. Then it prohibits all parties, attorneys, staff, court personnel, and any public official from disseminating information, commenting, discussing, or otherwise opening on the merits, defenses, facts, or any other matters relating to this case outside of court hearings, signed without a hearing.
Pushback. The Columbus Dispatch has filed a complaint with the Ohio Supreme Court asking that High Court to bar Judge Rogers from enforcing the order. Attorneys for the Dispatch cited case law, writing, "Therefore, a gag order may issue only if specific findings are made, demonstrating that there is a substantial probability that the defendant's right to a fair trial will be prejudiced by publicity that the gag order would prevent, and reasonable alternatives cannot adequately protect the defendant's fair trial rights." The complaint continued, "Because the motion was not supported by any evidence, respondent could not have established a substantial probability that Ciders' right to a fair trial will be prejudiced by publicity that the gag..."
The Columbus Dispatch filed a complaint with the Ohio Supreme Court, asking that High Court to bar the judge from enforcing the order. Their attorneys cited binding case law. A gag order may issue only if specific findings demonstrate a substantial probability that the defendant's right to a fair trial will be prejudiced by publicity that the gag order would prevent, and that reasonable alternatives cannot adequately protect those rights. The complaint continued, "Because the motion was not supported by any evidence, respondent could not have established a substantial probability that Ciders' right to a fair trial will be prejudiced by publicity." In other words, the order was built on error.
So let's bring in Mark Weaver. He's been on many times. He's a former Deputy Attorney General for the state of Ohio. He works as a special prosecutor. Sometimes he works as a judge in the state of Ohio. Mark, you believe that this gag order signed by Judge Rogers, requested by Gary Jr.'s lawyer, is too sweeping and too broad.
I do. I'm not involved in the case. I know many of the players, a lot of good people. They're all trying to do the right thing.
We brought in Mark Weaver, former Deputy Attorney General of Ohio, a special prosecutor and sometimes judge, and a man who taught media law at Ohio State. He believes this gag order is not just unusual, it is contrary to law.
The order, it appears to ban all public officials from commenting, not just those like the prosecutor or the sheriff. The governor of Hawaii is a public official.
Right,
the
exactly.
Secretary of Health and Human Services, Robert Kennedy Jr., is a public official. I don't think she meant to gag people who are not involved in the case, but the wording of the order is overly broad.
Technically, Mark, you could be considered a public official because you work as a prosecutor for the state of Ohio.
I could
at
be held in
times.
contempt.
As
Oh
a
my
judge.
goodness. I could be held.
I taught media law at the Ohio State College of Law for many years, so I know about gag orders. I argued the seminal case in the Ohio Supreme Court on gag orders. I know gag orders. And when I read that the judge had signed this without having a hearing, I knew immediately that this was contrary to Ohio law. That is not advocacy. That is a legal fact check.
When one side files a motion with a judge, asking a judge to do something, it's typical to include what's called a proposed order. This is, dirty little secret, a way for the judge to save time. Hey, judge,
Right.
if you don't want to write up your own order, here's a handy-dandy version of an order you can use. Some judges will take that and write their own. Others will just sign it. This judge signed it. How do I know that? Because what she signed.
Then Weaver pointed to the language itself. When I read the order, it appears to ban all public officials from commenting, not just those like the prosecutor or the sheriff. The governor of Hawaii is a public official, right? The Secretary of Health and Human Services, Robert Kennedy Jr., is a public official. I don't think she meant to gag people who are not involved in the case, but the wording of the order is overly broad. The host noted that even Weaver, a part-time acting judge, could be in contempt. The absurdity exposes the core defect and order so sweeping it becomes a weapon against public oversight, not just pretrial publicity.
Right.
I think the judge needs to add you as a law clerk to her staff because you just summarized the law. Some of your viewers know, and I know you know, that I prosecuted a high-profile death penalty case along with the great Chris Tennell up in Ashland County of a serial killer named Sean Great. Long Crime Network covered the trial. This is a few years ago. In that case, prosecution, our side, and the defense of the serial killer agreed there should be a gag order, and the judge signed it. When that happens, according to the Ohio Supreme Court, there's not a hearing that's necessary.
And how do we know the judge didn't write this order herself? Weaver explained the dirty little secret. When one side files a motion, they often include a proposed order to save the judge time. Some judges take it and write their own, others just sign it. This judge signed it. The proof, the signed document still says proposed order. At the top, not simply order. A template was accepted without a single alteration, without a single question, signed without a hearing.
A little bit behind the scenes, did not agree to it. It was one lawyer for one of the defendants filing this motion, and the judge simply signed it. So the judge has a way out. And I mentioned it, I wrote an op-ed in the Columbus Dispatch about this exact topic. People can read it online, it's on my X feed. And if you want, you can retweet it, people can see it. The judge has a way out, and here's what I said in the op-ed. She should simply revoke her order, call for a hearing. At that hearing, allow both sides to introduce evidence, not opinions, not guesses, but evidence as to why we can't have a fair trial without a gag order. People always...
Weaver compared it to a high-profile death penalty case he prosecuted. There, both sides agreed on a gag order, and the judge signed it. Under Ohio Supreme Court precedent, when both parties agree, no hearing is necessary. But here, the prosecutor did not agree. One lawyer for one defendant filed the motion, and the judge simply signed it. That is the procedural fracture point. The state's voice was silenced without the state ever being asked.
When I went on the docket and I saw the motion and then saw that it said proposed order, and I clicked on the document and she had signed it. I couldn't believe it. With no response, no written response from the prosecution. What's also...
Weaver laid out the remedy in an op-ed for the Dispatch. She should simply revoke her order, call for a hearing. At that hearing, allow both sides to introduce evidence, not opinions, not guesses, but evidence as to why we can't have a fair trial without a gag order. The standard for jury selection is not whether potential jurors know about the case, but whether they can set aside what they know and be fair. That standard does not require an information blackout across the planet.
Concerning about this, Mark, is that this is a case of public interest, not because it's a crime and it's so shocking to the conscience that 16 children could be kept in a house like this in the conditions described. I mean, that's shocking enough and should be an interest to all people because our children deserve better than that. But also there are a lot of very serious questions in this case that the public and the government, I think, are required to answer. Were these people receiving benefits? If they were, what were the checks and balances on that? And had they had contact with this family before? And if they had, or...
The host herself was stunned when she pulled the docket and saw the signed proposed order with no written response from the prosecution. That shock is the correct reaction from anyone who understands due process. But something even larger than a flawed order is now hidden behind it.
That's certainly true. Your viewers may not know this, but the Ohio Controlling Board, which spends money for Ohio tax purposes, just approved $1 million just for this case to take care of these children. I've never seen this before. I've been in and around controlling board business for many years in Ohio. To have them set aside from the state budget a separate $1 million expenditure simply for this children. I'm not saying they don't deserve it. I'm not saying that at all. What I'm saying is that's very unusual. That's how big a deal this case is, that the state budget now has a separate line item to help take care of these children. That's remarkable.
And that kind of makes me wonder if they realize that the children's services in this area might be severely underfunded.
This is a case of public interest, not only because of the crime's shocking nature, 16 children kept in conditions that should offend every conscience, but also because there are hard questions the public and the government are required to answer. Were these people receiving benefits? If they were, what were the checks and balances? Had agencies had contact with this family before? What fell through the cracks? Why was there no effort to find them? These questions are not about one trial. They are about a system that may have failed for years. Here is where the story becomes a thriller. What happens when the only people who can answer for that systemic failure are legally forbidden from uttering a word? If a gag order can be signed without a hearing in a county of 13,000, what stops the same mechanism from being used elsewhere, sealing the next house of silence before the public even knows it exists? Are we watching the first trial or the first cover-up template?
The rules for how fast a trial has to occur once somebody has been arrested and taken into custody and charged, they don't change between small counties and big counties. Those timing schedules still exist. So unless the defense is willing to waive their speedy trial rights, we still have speedy trial considerations here. So you can't dawdle too much. And even though a grand jury only meets every so often, you can ask for a special meeting of the grand jury. Your last point, though, is the final thing I would mention is it is difficult to get the evidence you need processed by the crime labs that are overwhelmed with evidence, particularly digital evidence. So if they're using phones or devices to find out what happened, it could take...
The state's own actions reveal the scale. The Ohio Controlling Board just approved a separate $1 million line item from the state budget just to take care of these children. Mark Weaver said he has never seen that before. $1 million set aside for 16 victims suggests a failure so profound that even the state is acknowledging it with an emergency cash allocation. And it makes you wonder whether local children's services are so severely underfunded that the cracks were not cracks at all, but canyons.
At the time of this recording, there's been no response from the judge to that request about the gag order to the Ohio Supreme Court. Gary Jr., Elizabeth, and Christina Ciders, they're all still in jail. They're being held on that $300,000 bond. Gary Sr., as I mentioned earlier, is in the hospital receiving treatment for medical care. All have pleaded not guilty to these charges. The next step in this process, a grand jury will hear the case. So stay.
Meanwhile, the clock is ticking. Speedy trial rules apply in Vinton County just as in Columbus. Grand juries meet infrequently in small counties, but special sessions can be called. The digital evidence, phones and devices, must be processed by overwhelmed crime labs. The defense will not wait forever. The state must move quickly, and it must move in the daylight. A gag order that silences every public official makes that impossible. Justice done in open court is not a slogan, it is a structural requirement. And this order threatens to replace open court with a sealed room.